Hello, everyone. Welcome to, I guess, our last session as part of SOPtoberfest. I'm Michael. I'm here today with Matt Bryan, one of the special counsel in our team, and Pat Ireland, a senior associate in our team. And yeah, I guess we're at the end of October already, which is a bit terrifying. Melbourne Cup next week. What we've run through over the course of the last month have been a few things. So I guess we started out, we've shot through payment claims, we've worked through payment schedules, we've worked through the process of adjudication, we've worked through enforcement as well. I guess the purpose of today's session was just to sort of wrap it up and probably share what some of our experiences are at the moment and what we're seeing. So I might sort of pepper Matt and Pat with some questions and stories about what their experience is going at the moment. But I guess as a starting point, Matt, I might throw to you. What's the vibe like at the moment in terms of security payment? Is it getting busier? Is it quieter? What's been going on over the last 1, 2, 3, 6 months that you've seen?
I think it has started to pick up. I think I've certainly noticed some more frequent inquiries and even if it's just people wanting to know what their position is in relation to potentially making a claim as opposed to just claiming under their particular construction contract. So I think there was a little bit of a lull there during the COVID period, the shutdown, the construction shutdown in particular, and possibly there was a little bit of a ceasefire in the case of some contracts, but I think business is starting to pick up a little bit in the SOP space, certainly.
Yeah, I think that's probably the right word to use there, Matt. There seemed to be, the ceasefire. I don't know if guns got put down for the first half of the year, but people weren't certainly, taking the first shot. Pat, what about you? You've been working on some big projects at the moment, and there's always the whispers in the background of adjudication.
Oh, definitely. And there's been a lot of clients that are and just people generally in the industry that are looking to upskill, because it is such a vital tool, as opposed to claiming under a contract like Matt said, and going through 12 months of court or more. So that there's definitely a lot of people that are wanting to make sure they're in the right position to use the adjudication process. Definitely.
Do you think Pat, still on you, do you think the construction shutdown has amplified the need to sort of get that cash flow going again? I see our Premier in the last hour or so has come out and said the shutdown was a terrible idea, and that was one of the missteps of the government. I think a lot of people in our industry have been feeling that way for a while, but has that had an impact on adjudication, do you think? I mean, this is all anecdotal.
Oh, definitely. I think so. I mean, that few weeks definitely put a strain on a lot of people's bottom line, and once those a few overdue claims start piling up, it's it's time to really get your ducks in a row and make sure you're able to use the adjudication process.
Yeah, I think that's meaningful. I know, Matt, we've seen a few times where it's not just the final claims seem to be a red hot item at the moment, as well as on some projects that accumulation of claims, something's 3, 4, 5 months in without being resolved. Where do you go to?
Yeah, I agree with that. I think sometimes it is a case of an inquiry where someone wants to bundle in a few claims that have already been made into one payment claim and go off to adjudicate and have that all determined in one hit, to the extent that's possible under the Act. So it may be, as Pat said, people are sort of coming out of that shutdown period, having a look at where they're at, what their cash flow looks like, and then having to make some decisions about taking enforcement action where there are payment problems.
Yeah, and so I guess that leads into one thing: the tips you give to people at the moment. I guess you're on the coal face. You're seeing some of the claims that are coming in. What do people need to be doing? Where are the missteps? Where do the missteps continue to be, Pat?
I think, well, obviously, in addition to the fairly obvious ones being the timing of claims, and actually describing the work correctly and making sure you're claiming the right amounts in your contract, under the contract and in your claim are the documents that you need under your contract to support the claim. So, for instance, there's a number of cost plus contracts out there which require timesheets, subcontractor invoices, that sort of thing, to be included with your claims. For the larger projects, it might be an updated program, something like that. So it's definitely critical to really nut out and make sure you've got a checklist of all the hurdles you've got to cross in order to make sure your claim complies.
What about you, Matt? Any hot tips for people that need to be making claims at the moment?
I think Pat mentioned this. That it's really a timing issue. I think creates a problem more often than not. It's someone issuing a claim too early, for example, and not necessarily waiting for that key date to come and go under the Act. And often people see it as a due date rather than a date on which the entitlement actually accrues. So they beat that date and think it's okay. But if the relevant date is the last day of the month, this month, for example, issuing it today isn't going to result in a valid claim under the Act. You have to wait till the 31st and then take it from there. So I think most people nowadays, particularly people who have had some sort of exposure and familiarity with the Act, are able to sort of identify the construction work, identify the amount that's being claimed, and most of the time add those magic words that now need to appear in each case, the reference to the claim being made under the Act.
Only most of the time, though, isn't it? I think, Matt, you and I have seen even in the last week two occasions that I can think of where the magic words have been missing.
Yeah, and sometimes that's right, and that's the difference between making a claim under the contract and under the Act. That requirement's been restored now, and it's fatal. Those words need to be there for sure. And as I said before, it's really you need to wait and make sure that your entitlement to make the claim has arisen, and then you can go from there, hit the ground running.
Yeah, great. So jumping forward, let's say you've received a claim. The claims come in, it's not what you expect it to be. You don't intend to pay the full amount. What's the advice that we're giving to people responding to claims at the moment? Happy for anyone to jump in here.
I think firstly is making sure you've got it in by the due date, and making sure you know exactly when that due date is. Particularly if there's an earlier time rather than the 10 business days. If there's an earlier time noted in the contract, that's under that Section 14, that's critical. And probably second only to that would be the ensuring that any reasons you have for withholding payment are not just stated in a one-liner as well. It's really worth getting a bit of detail in there around why you're not going to pay the claim.
I think that's important, isn't it, Pat? Matt, you and I are dealing with one and the consequences thereof as we speak, but not fleshing out the detail when that might be a minimal amount of time that saves a maximum amount of effort later on.
Yeah, I agree. I think your reasons don't have to be articulated in the way that they might perhaps need to be if you were commencing court proceedings, for example. But there needs to be a sufficient amount of detail to put the other side on notice of the issues you're putting in dispute. So if you're withholding money for any particular reason, your payment schedule is your optimum chance to set out the reasons why and make sure there's no dispute that arises later on down the track about whether or not you can expand on those reasons and make submissions in an adjudication response. Because if you don't say something in a payment schedule, that's really the end of the story.
But it can stop that dispute in the tracks. I mean, we've both been advising owners and subcontractors and contractors for long enough. Like a well done payment schedule that gives legitimate, well articulated, explained, non-inflammatory. I'll sort of add those words in their reasons. If people understand why an amount isn't getting paid, it's a pretty good way to avoid a dispute that doesn't need to happen.
Yeah, I think that's right. I was just about to make that same point. Sometimes if you have a detailed enough payment schedule, that can dissuade the other side from even putting on the adjudication application, and whether or not that just sort of postpones things and they try and issue another modified or more detailed payment claim the following month, or whether it stops the whole thing in its tracks, I think, yeah, it's important to, I suppose, not hold back in your payment schedule. If there's some reason that you want to rely upon, that's your opportunity to say it.
But when you say not hold back, that's in terms of the detail, not in terms of the language, right, Matt?
Correct. Yeah, the basis for withholding the money, it's not your opportunity to say what a bad person the claimant is.
Yeah. I mean, Pat, you've spent a lot of time this year in one of your roles, and without going into too much detail, having to look at pretty detailed claims coming in that like the problem wasn't addressed properly. And of course, then when the payment schedule went back, it kind of became that perpetual cycle. Is there any tips that you think about how the payment schedule can be used to break that cycle, or is it just the best way to bring the dispute to the fore?
I think particularly on the on larger projects where there's a lot of correspondence going back and forth, if you're responding to a payment claim that's come through in say an Excel spreadsheet, and you're responding with an Excel spreadsheet, and you may have line by line answers, it's important that any reasons that are that can't be put into that little one-line response are adequately linked to it or provided. So if there's other correspondence, things to ensure the story that you're trying to, or the narrative that you're putting forward is as clear as possible, it's important to have those in there.
Right. Well, I think the connectivity, I mean, one of the things I regularly see is the person preparing the schedules or the claims, we can sort of deal with those documents holistically, aren't the ones on the ground, don't have enough detail, aren't communicating well within their own team. So, I mean, the amount of times we've said where 100% of a piece of work, particularly on those larger projects, has been claimed, and then when we're at the dispute point and we're talking to the guys that are delivering the work, they're like, oh, look, it probably really is 85. And we've gone, well, they've assessed 87%, so we're probably 2% better off. Having that communication piece running both internally and using those documents as tools external becomes really important. The other issues, I think, we start to see is people don't actually link the problem or the basis for non-payment back to the contract. I mean, it goes both ways, doesn't it? If you're claiming an entitlement under the contract, you should identify where. If you're responding as to why there is no entitlement, it should have some basis under the Act or under the contract, right, Matt?
Yeah, that's right. If it's not a jurisdictional issue in terms of compliance with the Act, if it's an issue arising under the contract, then it's important to articulate what that is and make reference to the particular provisions that you're relying upon. And look, in some respects, it just sets up the basis. It's sort of an outline, if you like, of what you might go on to say in your adjudication application. So, and the same in respect of a payment schedule, it sets the scene for the adjudication response. So, ticking off on those contractual clauses that are in play, highlighting them, and then providing some level of detail of why you're putting it an issue. I think is a good way to structure the claim. And if it then becomes a situation where there is some allegation of an offsetting claim, or there's defective works and things of that nature, that can be highlighted. But at the same time, that can also sort of be linked back to the contract as well. There's usually, obviously, clauses outlining particular quality requirements. So it can all be linked back to the contract, and I agree with you. I think it should be.
Great. I'm going to throw one more at you, Matt, before I'll pull Pat in for something. A favourite topic, absolutely favourite: delay damages and security of payment. How do they mesh together, or do they?
It's a difficult sort of area. I think, as a general rule of thumb, you should proceed on the basis that if your delay damages arise directly as a result of a particular clause of the contract, you can proceed under the Security of Payment Act. But if you are making a claim for general damages or common law damages, you're going to run into some difficulties. So if there are clauses in the contract that give you a particular right, either to liquidated damages, or if you're the builder, delay damages, and there are amounts that are crystallised in there, I think there's a basis for claiming those under the Act, including by way of offset if you're the respondent. But yeah, damages at large, as a general rule, you have to go to court in the ordinary way in order to sustain that sort of claim, I think.
And that includes if you're a claimant and you want to claim for, all those fun words like consequential loss, loss opportunity, all those things fall out of this regime.
Yeah, the loss of profit and losses of rent and all those types of things. Yeah, I think that's right.
I'm going to jump to you. Another favourite topic, service. How should people be getting these documents to the other side?
Well, it's important to know what your contract says. Firstly, if it's not a particularly detailed contract around service, then you're better off to be safe and sorry and take the greater measure to serve it in person. But yes, your contract will detail it and ensuring that it is actually served on the day that it needs to be, not put in the post that evening and it might rock up in 2 days or something like that.
And what do you say to the people, and no one on this webinar at the moment is these kind of people, so I'm putting them in a different box, but the ones that try and be clever, I'm working on, let's say, I don't know what's a project that's live. There's a Sydney Metro live project at the moment. We know that a tier 1 contractor has a little satellite office in the middle of, out of Condobolin. What about the people that try and be tricky and serve those on weird and wonderful places? What's your thoughts?
Well, the contract will usually, on a project of that sort, it'll usually have an office address. And yeah, as I said, better to be safe and sorry and play by the rules rather than try to be too clever.
Yeah, thanks, guys. Okay, so we move on to, let's say you've got a payment, you've put in your payment claim. No payment schedule has arrived on time again. It probably shows the heat of security of payment at the moment that I can say we've had a scenario just like that happen this week. Again, Matt and I, these are all across different projects. Can I ask each of you to do an advocacy piece? If we put on the two hats, I suppose, if no payment schedule has been received, you've got the two options. You can either start the 17.2 notice and go to adjudication, or you can roll down the path of summary judgment. Pat, can I start with you? Why you would go towards summary judgment, and maybe why you wouldn't, and what that involves?
Yeah. Okay. Well, it's a great, I suppose, tool to turn up the heat a bit on that claim. If there is no potential defense or offsetting claim floating around, then it can be a much clearer process, and I suppose much quicker as well. But if there is potentially a jurisdictional issue with your claim, or there is an offsetting claim against your payment claim, you can run into some difficulties in pursuing summary judgment. Whereas I suppose adjudication, the process there is, you've got to get that 17.2 notice on and then await a payment schedule in response to that 17.2 notice, and then the adjudication process proceeds as it would, as if there was a payment schedule.
Yeah, and I suppose with that summary judgment process, Matt, you might have some thoughts here. I shouldn't say success, that's not a fair way to put it. I mean, a good claim's a good claim, but the court's comprehension around this legislation differs quite significantly from Supreme, District and local courts in my experience. I mean, it's just to do with the volume of material and types of lists that are there, but is that personally, I'm less inclined to go for summary judgment for 20 grand than potentially I might be for 2 million. Matt, do you?
Yeah, I think that's right. I think the main things that I would ask a client about before making a decision about which way to go include how much is in issue, whether or not you think that the claim, as Pat said, might be subject to any sort of jurisdictional attack, and whether or not, for that reason, summary judgment might end up being the longer and the more expensive way to the finishing line. And thirdly, just the type of claim and the nature of the commercial relationship, I think factors in to some extent. And lastly, and not necessarily at least, the question of cost, I think, because you can generally recover your costs if you're going via the court route, whereas you can't recover legal costs that are incurred in connection with the adjudication. So I think it's a combination of all those things. But yeah, I agree with you. It's with those larger sort of claims that come before, the specialist construction judges in the Supreme Court. Those judges certainly tend to see a lot more of this type of stuff than judges in the district court and magistrates in the local court who are dealing with a whole variety of stuff on any given day, and probably have slightly less in terms of resources to enable them to deal with busy lists as well. So it's a combination of factors, I think. But I think ultimately the most important consideration is probably how exposed you are, if at all, to any sort of jurisdictional problem, because that's really the easiest way to defeat a summary judgment application is to raise a technical argument along those lines.
And they can be, people often raise more than one and try and muddy the waters, and that can have a degree of success, particularly in those busier local courts where maybe a bail application is interrupting what is otherwise quite a technical argument.
Yeah, it stunts the momentum for sure.
I'm going to throw to a question that's come across from Kerry. Again, if anyone else has questions, please put them out there. It's going to move on to a topic I love that shows, so maybe I'm a nerd. But anyway, how do we use SOP to gain payment from typical slow payers where there is no dispute against the claim and a payment schedule has not been issued? Is the process of adjudication solely for disputed claims? I'm happy to go to the floor for that if either of you have comments, and I suppose it ties into a tool that I love to talk about, and I'll ask one of you to cover it, the power of suspension.
Yeah, well, I think it sort of flows on from what we were just talking about in terms of making an election between going off to court and trying to enforce what is a statutory debt that has arisen, and getting default judgment and going from there on the one hand, or giving the other side a second opportunity to put on a payment schedule and then taking it off to adjudication. If you don't receive a payment schedule, having given the other side a second chance to provide one, you can still go off to adjudication, and it's not necessarily a situation from there where your application will just be rubber stamped. You still need to tick all the boxes and persuade an adjudicator that there's an entitlement there. But it will be typically easier to do that when there's no submissions being put against you by the other side. And if a payment schedule hasn't been provided, then no adjudication response can go on. So it's really a situation of making a choice between those two limbs. But as you said, Mike, the other thing you can do is to exercise a right of suspension under Section 27 of the Act by giving the other side 2 business days notice of your intention to do that. And you get a degree of protection as well under the Act, because it says that if you validly suspend, you're not liable for any costs that are incurred by the other side as a consequence of that. So that's also a very good way of applying a degree of commercial pressure, and to also put yourself in a position where you're not continuing to incur costs and getting further behind the 8 ball where there's a payment dispute.
Yeah, and I think, Kerry, the 2 ones I like to think about, Pat, you might have some thoughts around this too. There's the slow payers, and I can say as a business owner, we have our slow payers, but I know they always pay. I know they pay outside my payment terms, so I eventually learn that, look, they're going to be a month or whatever late, and I can probably make a commercial decision to live with those. Then there's the ones that might be very slow payers on big amounts, and that's sort of business critical impact, or they might be very slow payers, not just on a big amount, but in an unusual way. And they're the ones I get concerned about, Pat. Pat and Matt, the ones that I get really stressed about are if someone has always paid big amounts on time and then suddenly ceases to do so, what is happening that we're unaware of?
And I think it's, as you mentioned, there's obviously the business relationship side of things, and if you're going to suspend work, it doesn't just have to be a suspension notice out of the blue and no further contact, that sort of thing. It can be presented as, this is we're working hard on this project for you. we have cash flow concerns of our own. This act is here for exactly situations like this. And if you're not going to keep up to date with the bills, then we're going to have to use it.
Yeah, I have one project. I'm going to get to Andrew's question next, but I have one project I think about with the suspension tool and where a good payer turned bad payer. This would be coming on 7 or 8 years ago, but 2 clients, same project, same head contractor they were working for. It was a fork in the road moment. Both we gave the advice you've got the opportunity to suspend. One chose to do so. They were about both were about $30,000 or $40,000 in the hole at that point. One chose to suspend, one chose to continue working, saying, if the project gets progressed, they'll get paid, we'll get paid, everything will work out in the end. And unfortunately, that meant there was a insolvency event down the track. The one that suspended ended up $30,000-$40,000 in the hole. The one that continued ended up $600,000 in the hole, and with no way out. It was a yucky situation. Both mum and dad type subcontractors. And both made different judgment calls on the same project. But to me, that just amplified the power of suspension. Yes, it doesn't fix everything. You do have slow payers and you can't always resolve that. But suspension is the one tool that I see that at least helps stem the bleeding. And other industries don't have the benefit of a power to suspend like the construction industry has provided through this legislation. So I hope in a roundabout way we've answered that for you, Kerry. Jumping on to Andrew, and I think this is a great question as well. Can a dispute resolution clause in a contract take precedence over the adjudication process through security of payment? If a subcontractor goes directly to adjudication rather than through the contract dispute process, could this work against the subcontractor? Matt, I might start with you.
Well, I think the first thing I'd say in response to that is there's Section 34 of the Act is the no contracting out provision. So it essentially provides that the Act trumps any provision of the contract. So I would say you can still deploy the security of payment process, and non-compliance with any particular dispute resolution clause couldn't necessarily be thrown up as an obstacle to you doing so. I think you can still use the SOP Act, and the same applies in respect of any other clause that might appear in the contract that attempts to sort of limit the effect of rights that would otherwise arise under the SOP Act.
Yeah, great. I mean, it comes down to that judgment call again too, doesn't it? Sometimes, Matt and Pat, you and I are discussing quite a substantial project at the moment where we may choose to use the contract process versus the adjudication process from a relationshipal perspective, even if we think the adjudication might be the faster and more direct route to a result. Yeah,
definitely. And I think it's that, obviously some larger contracts may have a number of steps that sit before your entitlement to go off to trot off to court and to make a claim under the contract. But it's that key thing that Matt mentioned. There's no escaping the Security of Payment Act if a party chooses to use it.
And no one.
I think that doesn't mean that you can't continue to have settlement discussions with the other side. Just because you've made a payment claim or you've made an adjudication application doesn't stop you from talking. And I've had plenty of matters where agreements have been reached before an adjudicator has had to hand down a determination. So those sort of things can run in parallel.
Yeah, great. Thanks. I hope that covered it for you, Andrew. Next thing I'll ask you both about, what do you think is involved in the art of good adjudicating or responding to adjudications? How do you go about it? Matt, can I start with you?
I think the key thing is to get your side of the story across in a succinct and a clear way. So I think the way I tend to go about it is to just tell the story in a chronological way and just break down the adjudication application, identify the issues that are put in dispute, and just try and deal with those in turn. And if there is a case, for example, where there's a set-off being claimed because of defective or incomplete works, that can be raised as well, preferably supported by some independent expert evidence if you're going to make allegations about defects and things of that nature. But it's really about making the adjudicator's job as easy as possible, I think. Just collecting together a whole bunch of documents and just jamming them into a folder and shooting them off is in some respects going to be counterproductive. I think if you can distill your submissions and the amount of documents that you need to support your case to the point where it's manageable, it says what you need it to say, and it hits on the points that you need to hit on to respond to the adjudication application, and also make good any counterclaims and things of that nature that you are relying upon. I think that's really the key. So simplicity, to the extent possible. Sometimes there's hundreds of items in dispute, and there's inevitably going to be a lot of material. But there's no use saying what you can say in one page in 10 pages. It just makes the adjudication process cost more, and it's more difficult for an adjudicator who only has a limited amount of time to sort of wade through it all.
I think, Pat, you and I have often talked about when you're preparing or responding to an adjudication, the restraints of that limited amount of time. We usually take, and I'm open to your thoughts around this, start big and small, right? Like if there's big ticket items, you start with those. You don't, necessarily work through it. This is item 1, it's worth $10. You start with maybe item 73 that might be worth $500,000.
Oh, definitely. And I mean, also if there's recurring themes in a number of claims that are made within or issues items that are claimed for, then it makes it much more efficient to really hit those in terms of the big claims. I think as Matt was saying, it's all about making your story the clearest and easiest to follow. And I think particularly on either long contracts and long builds, there can be a lot of contract specific sort of definitions that the parties have come to know very well. But what you've got to remember is that the adjudicator's never heard of either. Sometimes they've never heard of either party. They haven't heard of the project. They don't know what's going on. It's important to make sure that you're telling the story as if you were telling it to someone who knows nothing about it.
And I think that involves, construction is a complex, difficult, and varied industry. So there is a lot of benefit to explaining what the works actually are to start with. If you've got if you do a weird trade, or if you're doing an unusual project, you may need to go into some detail just to help the adjudicator get across the line and understanding what you do in the first place.
Yeah, definitely.
Yeah. So we go through the adjudication process. You win. We'll talk in the context of winning because we're moving into the concept of enforcing. So you've got through adjudication. You've had some measure of success. What are the tools available to you to actually get the money into your bank account? I mean, it's all well and good to have a decision that says yes, we can frame it and put it on the wall, but it doesn't pay. It doesn't pay for things.
I think. The first step is usually to talk to the other side. Sometimes the other side will come back and say, "Oh, well, we don't agree, and we're going to do this and we're going to do that. So why don't we just do a deal?" That can happen if there is no agreement in relation to that sort of thing. The first step is normally to get what's called an adjudication certificate. So that's something that comes from the authorised nominating authority. Who you apply to for adjudication in the first place. That can set out how much is owed. It can incorporate costs that have been paid and that are reimbursable by the respondent. It can include an interest component as well, if that's applicable. Then you register that in a court depending on the amount. So it can be local, district, or supreme. And then you can take the steps that you can normally take to enforce a judgment. So depending on how much is in issue, you can do things like issue garnishee orders. You can make applications under the Contractors Debts Act and try and secure payment from someone higher up the contractual chain than the other side. You can apply for writs of execution, and in cases where there are higher amounts at stake in the District and Supreme Court, Sometimes you can get charging orders, freezing orders, receivers can be appointed, things like that. Sometimes you're able to use the creditor's statutory demand process, which if there's a failure to comply with the stat demand, that creates a presumption of insolvency and can form a basis for a winding up application to be made to the Supreme Court. There's a bit of case law about when that can be used. And essentially, the simple answer is if there's any sort of genuine offsetting claim that the other side has, they can set that up as a bar to the statutory demand and apply to have it set aside on that basis. So if there's no offsetting claim of that type, there's no genuine dispute about the debt being payable, sometimes that's an effective way, sometimes the most effective way, particularly if there are large amounts at stake in terms of enforcement. So that's sort of a general summary of the type of action that you might be able to take. But the key thing is, the bottom line is, once the adjudication certificate is registered, it has the status of a judgment, and sometimes it will result in a black mark being entered against the other side's credit history as well. So you can use that as a little bit of leverage for payment as well. Particularly in situations where borrowing capacity might already be an issue. If there are some sort of cash flow problems, then people obviously don't want those things to happen.
Right, Pat, I'm going to ask you, one of the things that often gets put to us is, I don't want to adjudicate, that's going to spoil my relationship with whoever the person that isn't paying the money is. How do you respond to that?
Well, I think it's, as Matt mentioned a little bit earlier, or maybe you do, but I mean, it doesn't have to be a process where you're sending off, your adjudication application and you're not talking to the other side. It's, you can still be discussing it on a commercial level as you're going through the process, and the key thing in those situations really is to outline where the risk lies for the other side, and the fact that, well, essentially say we don't want to have to see this through, but if we can't come to some sort of commercial resolution, then we're going to have to take the formal action.
Right. And I suppose,
most of the time in those sort of situations, there has been a history of attempts to get payment across the line by agreement as well. So there's only so many times you can try and sort things out and receive a negative response. And at the end of the day, it might be a decision that you have to make between maintaining a commercial relationship or getting paid at all. Obviously, people can't do work for free. They can't keep the lights on and pay the bills if the income's not coming in.
Yeah, and I think that's right. It does come to that commercial decision. I've spoken with a business in the last week that's choosing to aggressively chase some monies because they realised, it'd take another 10 years of ongoing relationship with this client to even come close to recouping it. They'd prefer to, lose the relationship immediately than to have it wane over the next decade and hope for the best. Other ones that comes up, rules of evidence don't apply in the same way in this adjudication process. It's a fast, efficient process, everything else, but obviously we've already spoken about the benefits of putting together well in a concise and clear way. We've all seen those adjudication applications or responses. Mudslinging is probably the politest way to put it. They're not far off drawing a picture of the other side with devil horns and everything else on the front page of the document. What are your thoughts? I mean, rules of evidence don't apply, but how do you approach those problems?
I think particularly in the construction industry, there's often so many documents flying around, claims, variations, EOT claims, things like that. And I mean, if you can tell a story with one sentence and then a document that was issued on time in accordance with the contract, it really hits home a lot better than writing 2 pages worth of unsubstantiated, fluff, really. Yeah,
I agree, Pat. Kerry, we've got another question coming through. I'll leave it open to either of you to cover. if there have been multiple attempts to come to a commercial agreement directly with the client to no avail, how do we start the timeline again to then be able to submit an adjudication process after the initial timeline has lapsed from the original claim? It can be a bit complex, can't it, Matt?
Yeah, sometimes it can. I think you can reissue a payment claim if you have another date that arises that entitles you to do that. So the dates on which payment entitlements accrue, it'll either be the last day of each month under the Act or any earlier date that's set out in the contract. So you can only issue one payment claim per month ordinarily. And it's a case of if you've issued one claim and the time to go off to adjudication, for example, has come and gone, or you've received a payment schedule and nothing's come of it, it's a question of whether or not you have the entitlement to reissue that in the next month. That's really what it comes down to in terms of pressing that entitlement under the SOP Act, I think.
And sometimes that moment in time has gone. I mean, again, in the last month, I've given that advice they're outside of the 12-month window. The claim will be made in the usual way. In this case, it'll be a claim made through the Supreme Court if a commercial agreement can't be reached shortly. It's a tool to facilitate prompt payment through the industry. But sometimes, all the boxes aren't ticked, but it is worth having a look at to see if that can be a starting point, because I think we all share the view that it can be a really fast, efficient, effective way to get some payment rolling in.
Yeah, I think that's right. And look, going back to what I was saying a moment ago about the creditor statutory demand process, like that's really something that you can use when there is no genuine dispute about whether or not an amount is payable. So that might be an alternative way in which to try and approach the problem. Obviously, if all else fails, as you say, Mike, the court process can be used in the ordinary way. And in some of those situations where there's no dispute about payment, but it's just a cash flow problem, sometimes the other side won't file a defence and you'll be entitled to default judgment, and you would be in the same sort of spot that you're in if you went off to adjudication and then registered a certificate. So it's a few different ways of skinning the cat, but look, the SOP Act is a good way of trying to fast track the resolution of a problem like this if it's available.
We're coming to the tail end. If there is any other questions, please let us know or reach out to us afterwards. I'm going to ask, part of the reason we do this in October is, we're edging towards the end of the year. Projects are potentially coming to a close. Money needs to come in. There's the Christmas shutdown looming. What is it today? Halloween's on Sunday, so by Monday morning there'll be Christmas decorations hanging in every shop. It is important if you need cash flow going into Christmas. Now's the time to use the Act. Matt, Pat, do you share that view, or do you have a different thought?
Oh, definitely. And I think particularly around there can be on the other side of the coin as well, that if there's a number of claims that have stacked up, like there's I've seen parties before where they decide to make that last claim of the year the big one and the really well put together one in order to put the pressure on the other side. So it's also really important coming into the end of the year to know how the Christmas period and New Year's period interacts with the business days, I suppose, aspect of the Security of Payment Act.
I think that's right.
I think that's a good point. Yeah, the Act sets up a system where business day is defined to mean a day other than a public holiday, a weekend, or I think it's the 27th to the 31st of December. So you sort of got to be careful in calculating your business days over that little period.
But also, if you're shutting down your office over December, January, and a lot of people do, or critical people are going on leave, don't be caught by surprises. I think, having people checking the relevant email boxes, the mail boxes, under the door at the office is important, even with those shutdowns. And COVID's probably made it less relevant than it used to be. But I used to joke, like, you don't want people that are really important on projects to disappear on projects where there's contests to disappear to Colorado or the Italian Alps and turn their phones off, because I've had that happen. Trying to get in people have intentionally served it when they know that critical decision makers or advisors are away. So really map out what if there are disputes in the wings and who the people are going to need to address it, because in the absence of those, you may not be able to make or respond to a claim as effectively as you'd like.
Sure.
Yep. Okay, guys. Well, I think that brings us to the end of SOPtober 2021. Obviously, any other questions? There's a resource bank that's going to be shared through our team in the at some stage next week. Appreciate Matt, Pat, everyone else that's contributed. Thank you. And if there's any other questions, please don't hesitate to reach out. I think the first job on my desk after I walk out of this is settling a payment claim. So it is a very active topic at the moment. But yeah, all the best to everyone that's come along and their businesses, and thank you for making the time. Thanks, Pat. Thanks, Matt.
Thank you.
Thanks very much.